You were convicted of drug possession 10 years ago. Simple possession, not dealing, not trafficking. You had a small amount of for personal use. You served your time. You completed probation. You've been clean ever since. But under federal law, that conviction made you a prohibited person for life. You can never own a gun again. At least that's what the government said. But on January 27th, 2026, the Fifth Circuit Court of Appeals said that's unconstitutional. The case is United States versus Hembree. And the court ruled that disarming someone for life based on a simple drug possession conviction violates the Second Amendment. This is a massive win for gun rights and drug policy reform, but it's also limited. The ruling only applies in the Fifth Circuit, which covers Texas, Louisiana, and Mississippi. And it's already creating a circuit split. Other circuits might rule differently. We need to understand what this decision says, what it doesn't say, and what it means for the future. Because if you have a drug conviction, this case might restore your gun rights, or it might not. It depends on where you live and what happens next. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal is one of the most significant gun rights victories in years, but it's also legally complicated and geographically limited. Understanding the details could mean the difference between getting your rights back and staying prohibited. Hit that subscribe button right now so you never miss updates on when this ruling spreads to other circuits or gets appealed to the Supreme Court. Here's what happened and why it matters. Hembree is a man who was convicted of simple possession of methamphetamine. He wasn't dealing. He just had for personal use. It's a nonviolent drug offense. He was sentenced under federal law. He completed his sentence. Years later, Hembree was found in possession of firearms. The government charged him with being a felon in possession of a firearm under 18 U.S.C. section 922 G1. That's the law that says if you've been convicted of a felony, you can't possess firearms. Hembree challenged the charge. He argued that permanently stripping his gun rights based on a nonviolent drug conviction violates the Second Amendment. The district court rejected his argument, but Hembree appealed to the Fifth Circuit, and on January 27, 2026, the Fifth Circuit reversed. The court said the government cannot permanently disarm someone based solely on a conviction for simple drug possession. The Fifth Circuit's reasoning was based on Bruen. The court asked, is there a historical tradition of disarming people convicted of nonviolent drug offenses? And the answer is no. Historically, governments disarmed violent criminals, people who posed a danger to public safety. But drug possession? That's a modern crime. Drug laws, as we know them today, didn't exist in the 18th or 19th centuries. There's no historical analog for permanently banning gun ownership based on drug possession. The government argued that drug users are dangerous because drugs impair judgment, but the Fifth Circuit said that misses the point. Hembree was convicted of possession, not use. And even if he was a user, the government's argument conflates status with conduct. You can't permanently ban someone from owning guns based on past conduct that's no longer happening. If Hembree is clean now, the government has no basis to disarm him. The court distinguished this case from laws that prohibit carrying while intoxicated. Those laws are constitutional because they're conduct-based and temporary, but a lifetime ban based on a past conviction has no historical support. Therefore, it violates the Second Amendment. This is huge. The Fifth Circuit just said that drug convictions, at least nonviolent ones, cannot be used to permanently strip gun rights. But here's the catch. The ruling is limited to the Fifth Circuit. If you live in Texas, Louisiana, or Mississippi, this decision protects you, but if you live in California, New York, or Illinois, it doesn't. Those states are in different circuits, and those circuits haven't ruled on this issue yet. So the law is different depending on where you live. That's called a circuit split. And circuit splits are how issues get to the Supreme Court. When circuits disagree, the Supreme Court steps in to resolve the conflict. So we might see this case, or one like it, go to the Supreme Court in the next year or two. If you're finding this helpful so far, imagine what you'll learn in my next video where I compare the Hembree ruling to the Hembree case that is currently before the Supreme Court and explain how they interact. Subscribe right now so you don't miss it. Now let's talk about the practical implications. If you have a drug possession conviction and you live in the Fifth Circuit, you might be able to get your gun rights back, but it's not automatic. You can't just go buy a gun tomorrow. Here's what you need to do. First, consult with a criminal defense attorney and a firearms attorney. The Hembree ruling doesn't expunge your conviction. It just says the government can't use that conviction to ban you from owning guns, but you might still have procedural issues to work through. Second, if you're currently charged with being a felon in possession based on a drug conviction, you have a strong defense. C.D. Hembree. Argue your conviction is constitutionally insufficient to support a gun prohibition. Your lawyer will file a motion to dismiss based on Hembree. There's a good chance you win. Third, if you already served time for a felon in possession charge based on a drug conviction, you might be able to challenge your conviction. Talk to a lawyer about post-conviction relief. Hembree could be grounds for overturning your sentence. And fourth, if you're thinking about applying for a gun, understand the risks. The Hembree decision is new. The ATF might not recognize it immediately. If you try to buy a gun and answer the felony question on Form 4473 truthfully, the dealer might still deny the sale. You might need to bring a lawyer and fight the denial. It's going to be messy for a while as the system adjusts. Now, quick legal note. This is educational information, not legal advice. If you have a drug conviction, consult with attorneys in your jurisdiction before attempting to own or purchase firearms. The law varies by state and circuit. Do not assume the Hembree ruling applies to you without legal guidance. Let me give you real-world examples. Imagine a guy named Mike. Mike lives in Houston, Texas. 10 years ago, he was convicted of possession of methamphetamine. Small amount, personal use. He served 6 months. He's been clean ever since. Mike wants to buy a gun for home defense. Under the old understanding of the law, Mike is a prohibited person for life. But after Hembree, Mike has an argument. His conviction is for simple possession, nonviolent. The Fifth Circuit said that can't be used to ban him from guns. Mike hires a lawyer. They navigate the process. Mike gets his rights back. That's the dream scenario. Now imagine a different situation. Imagine a woman named Lisa. Lisa lives in Chicago, Illinois. She also has a drug possession conviction from years ago. She's clean now. She wants a gun. But Illinois is in the Seventh Circuit, not the Fifth. Hembree doesn't apply to her. If Lisa tries to buy a gun, she'll be denied. She'd have to sue and hope the Seventh Circuit follows the Fifth Circuit's reasoning. That could take years, and there's no guarantee the Seventh Circuit will rule the same way. Lisa is stuck until more circuits adopt the Hembree rule or the Supreme Court resolves the issue. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about the connection to the Hembree case. Remember, the Supreme Court just heard oral arguments in United States versus Hembree on March 2nd, 2026. That case is about whether the government can ban current drug users from owning guns. Hembree is different. Hembree is about past drug convictions. The two cases are related but distinct. In Hembree, the issue is whether using drugs makes you a prohibited person. In Hembree, the issue is whether a past conviction for drugs makes you a prohibited person. The Fifth Circuit said no to the conviction-based ban. We're waiting to see if the Supreme Court says no to the use-based ban. If the Supreme Court strikes down the drug user ban in Hembree, that strengthens the argument in cases like Hembree. Because if you can't ban current users, you certainly can't ban people with old convictions who aren't using anymore. The two cases work together to chip away at drug-related gun prohibitions. Now let's talk about what the government will do. The Department of Justice is furious about Hembree. They put out a statement saying the decision ignores public safety. They're saying drug offenders are dangerous and shouldn't have guns. But more importantly, they're considering an appeal. The government could ask for en banc review in the Fifth Circuit. That means all the judges on the Fifth Circuit would rehear the case, not just the 3-judge panel that decided it. If the en banc court reverses, Hembree is dead. Or the government could appeal directly to the Supreme Court. They could file a cert petition asking the court to review the case. If the court takes it, we get a nationwide ruling. But if the court denies cert, Hembree stands and creates pressure on other circuits to follow. We're watching to see what the government does. They have 90 days from the decision to file an en banc petition. So by late April 2026, we'll know if they're going to fight this. Let me give you another scenario. Imagine a guy named Tom. Tom lives in Louisiana. He was convicted of cocaine possession 15 years ago. He's been clean and employed. He's a productive member of society, but he's been unable to own guns because of his conviction. Tom hears about Hembree. He's excited. He thinks this means he can buy a gun now. Tom goes to a gun shop. He fills out Form 4473. Question 11B asks about felony convictions. Tom answers honestly, yes, he has a felony. But he explains Hembree to the dealer. The dealer is confused. He's never heard of this case. He denies the sale and tells Tom to come back with a lawyer. Tom is frustrated. Even though the law changed, the system hasn't caught up. This is the challenge with new court rulings. It takes time for dealers, the ATF, and state authorities to adjust. Tom will need to push the issue with legal help. Now let's talk about the historical analysis because it's critical. The Fifth Circuit emphasized that there's no historical tradition of disarming people for drug offenses. Why? Because modern drug laws didn't exist until the 20th century. The Harrison Narcotics Act was passed in 1914. The Controlled Substances Act was passed in 1970. Before that, were legal. You could buy them at a pharmacy. So there's no 18th or 19th century tradition of criminalizing drug possession, let alone using it as a basis to strip gun rights. The government tried to argue that historical laws against drunkenness or moral turpitude are analogous, but the Fifth Circuit rejected that. Those laws were about conduct, not convictions, and they were temporary, not permanent. The court said, you can't stretch historical laws that far. Under Bruen, you need actual analogs, not strained comparisons. The government didn't have them, so they lost. This information could literally restore your gun rights if you have a drug conviction and live in the Fifth Circuit. Subscribe now because my next video will explain exactly how to petition for restoration of rights based on Hembree and what documents you need. Hit that subscribe button. Now let's talk about what other circuits will do. The Ninth Circuit, Seventh Circuit, and Second Circuit all have cases pending that involve drug convictions and gun rights. Those circuits are watching Hembree. They could follow the Fifth Circuit's reasoning and strike down the prohibitions in their jurisdictions. Or they could disagree and uphold the bans. If they disagree, we get a clear circuit split. And that makes Supreme Court review almost certain. My prediction is most circuits will eventually follow Hembree. The reasoning is solid. Drug possession convictions, especially old ones, are not a basis for permanent disarmament under Bruen. But it will take time. Each circuit moves at its own pace. We might not have nationwide clarity until 2028 or 2029. Let me give you one more scenario. Imagine a woman named Sarah. Sarah lives in Texas. She was convicted of marijuana possession in 2010. She served probation. She's been a responsible citizen since. She owns a small business. She volunteers in her community. But she's been unable to own a gun because of her conviction. After Hembree, Sarah consults a lawyer. The lawyer files a petition to restore her gun rights. The court reviews her case. She's no longer a prohibited person under the Second Amendment. The court grants her petition. Sarah can now buy a gun. She does so legally and safely. This is the power of Hembree. It gives people like Sarah a second chance. It recognizes that a nonviolent mistake from years ago shouldn't strip your constitutional rights forever. Now let's talk about the dissent. The Hembree decision wasn't unanimous. One judge dissented. The dissent argued that drug offenders are dangerous and the government has a strong interest in disarming them. The dissent also said there's historical support for disarming people who violate the law. Felons have always been subject to restrictions. The majority responded by saying there's a difference between violent felons and nonviolent drug offenders. The historical tradition of disarming criminals was targeted at dangerous people. Drug possession, especially simple possession years ago, doesn't make someone dangerous. The dissent lost. But the dissent's arguments will be used by other circuits that want to uphold the ban. So the fight isn't over. Now let's talk about state law. Even if Hembree restores your federal gun rights, you might still have state-level prohibitions. Some states have their own laws banning felons from owning guns. Those laws would need to be challenged separately under state constitutions. The Hembree ruling doesn't automatically invalidate state laws. It just says the federal prohibition is unconstitutional as applied to nonviolent drug convictions. You'd need to check your state law to see if additional challenges are needed. Look, I spend hours every week reading circuit court opinions, analyzing Second Amendment cases, and tracking how gun rights are expanding so you know where the law stands and where it's going. The least you can do is subscribe to make sure you never miss a major ruling like Hembree that could change your life. Subscribe right now, and if you found this helpful, share it with anyone you know who has a drug conviction and has been prohibited from owning guns. They need to know their rights might have just been restored. Spread the word. Remember, this is educational information based on the Fifth Circuit's decision in United States versus Hembree. It is not legal advice for your specific situation. The ruling only applies in the Fifth Circuit. Other circuits may rule differently. Always consult with a criminal defense attorney and a firearms attorney before attempting to purchase or possess firearms if you have a felony conviction. Stay informed. Watch for in-bank review or Supreme Court cert petitions, and understand that this is a major victory for gun rights and criminal justice reform. People with nonviolent drug convictions are getting a second chance. This is what the Second Amendment is supposed to protect. Real people, real rights, real lives, and we're winning one case at a time.